Hello dear students, the video is about prospective overruling, a judicial interpretation or a constitutional interpretation. Before understanding this prospective overruling, let's have an idea about the types of laws, the formulation of laws. There are three categories, three tier laws. The first one is enacted laws. That means the laws being enacted by the parliament. The second one is amendment of the constitutional law, that is also by parliament. And the third one is judicial decisions in the court of law. And following the principle of stare decisis, we can just say that it is a precedent and we follow it. Yes, or we can say the judge made law. So the first one is enacted law by parliament, and the second one is amendment of the constitutional law, and the third one is judge made law. See, what is the nature, what is the effect, or are the problems in operation of these laws, different types of methods of laws? See, generally, at the time of operation, we will be facing a lot of problems by implementing the laws or the judge-made law. That means the established, according to the statues, the established law or the established judgment precedent. While implementing these things, sometimes the judges, the judiciary will be facing a lot of complications, complexities, because the present day society, the changes, a lot of reformations, a lot of transformations that occurred in the present day. So, in order to meet those challenging problems, day-to-day problems, day-to-day complications, legal complications, the old judgments or the old laws are not relevant, and we cannot meet the ends of justice properly. Then, what is the issue? What is the problem here? So, here the judiciary has to modify, rectify, amend the law, because the Supreme Court has the power to modify its own judgment or to nullify its own judgment, and it can also find fault with the established law by giving some suggestions. But the serious hurdle in this way for judiciary is this: the judiciary is expected to interpret law and expound law, but not to make law. It has no power to make law. So the intricacies, the complexities, and the subtleties involved in the law, it can trace out, judiciary can trace out and submit. For reformation, it can submit. And what is the way out for modification, amendment, etc., etc., for judiciary? The only way out is judicial activism, or we can say judicial creativity. How and when? Is in respect of bill, public interest litigation, in respect of judicial review, and in respect of sumoto cases, the judiciary can modify, amend, and even nullify the already established law or established earlier judgment. So these three are the ways, are the way out for a judiciary: bill, judicial review, and sumoto. And at the time of after having formulated a new law or a new judgment to the present, to meet the present day requirement, to solve the present day issues, legal issues, because there is every need to meet, the law should meet the test, it should have the test of the time. That means the law should stand the time. That means according to the requirements, latest requirement during the present time, the law should provide some solution. If there is no solution, the judiciary must, by out of its creativity, judicial activism, must modify, must formulate, or at least make a wonderful pronouncement, judicial pronouncement. How? In such a way that The provisions, the latest judgment pronouncement should be relevant to the present and the future cases, and not relevant to, or not, it should not have any impact on the old law or old cases. That means already decided cases, because there will be a lot of complications if it is applicable to the past one. So only to the present and the future. So that is called prospective overruling. That means the decision, the latest decision taken at present. See, for example, I would like to tell you, for example, this out of appeal, the outcome is the bill filed by Shining. The outcome is that judiciary has taken the decision, pronounced that the that adultery is not at all a crime. Once upon a time, it was a crime. Now it's not a crime, and the same judiciary has given a lot of judgments about it, punishing the male person, punishing the victims, sparing the woman. But now, with the advent of this Chinese appeal petition, the judgment delivered by Supreme Court is very sensational, really creative. Now it is said that no, but adultery is not at all a crime. It is only a ground for divorce. This is the judgment, and it is relevant to the present day and to the future, not to not with retrospective effect. That means it is not applicable to the past cases. Suppose already decided cases, some punishment was imposed, etc. No, it is not relevant to that. It doesn't have an impact on the old law or old cases. Only from today onwards and the future also, it is relevant. Now that means if at all anybody, if anybody, any married man or unmarried man has an affair with a married woman, now it's not a criminal offense. There is no punishment, nothing doing. It's only ground for divorce. That is relevant only to the present and the future. That means that is called prospective overruling, without touching the back. And one still more cases, established cases I would like to refer here is a fundamental case, fundamental issues case. That is Sankari Prasad, Golaknath, and Sajjan Singh, and then last case one of the Bharati case. First of all, in Sajjan Singh and Sankari Prasad, first of importantly, in Sankari Prasad case, what happened? The judiciary declared that Parliament has full power, that means absolute power, to touch upon this fundamental right. That means it can even amend fundamental rights. That was the decision delivered by the Supreme Court in Sankari Prasad, whereas in Golaknath, quite reverse. No, no, no. It has no power at all. It should not touch the fundamental right. It has no power. The Parliament has no power. But finally, when we come to case one and the Bharti, and that is why it is called fundamental rights case and basic structure case. So finally, in case one and the Bharti case, what has happened is that Parliament has full power, absolute, not absolute. It has the power, not absolute power. It can even touch upon fundamental rights, any part of the Constitution. But the only thing is, it should not be detrimental to the basic structure. And fundamental right is also one of the basic structures. Preamble, rule of law, all these are fundamental. Democracy, democratic setup, parliamentary system, all these are basic structures. So without being detrimental to the basic structure, it has the power. It can enjoy, exercise its power. The parliament can. That means it is not relevant to the past. It doesn't have any effect in the past cases, decided cases. It is relevant to the present and the future. That is called prospective overruling. I think you must have some idea about it. And why this kind of overruling, prospective overruling, was first occurred in American jurisprudence. This breakthrough of modifying, rectifying, and even nullifying the old orders or old judgments occurred first time in America, USA, in respect of that Cardozo, Justice Cardozo, was the first time. he took that decision of over prospective overruling in some cases because of the need, and later on British jurisprudence, and finally Indian jurisprudence. And Justice Subbarao made a very creative sensation while he was delivering judgments. But the thing is, important issue here is where and when. That means who can make such type of overruling judgments and where. The answer is it is the Supreme Court. Supreme Court alone has the power to take such type of judicial decisions, overruling the past and giving the judgments with prospective overruling. And another thing is when and in which issues, only in respect of constitutional matters. Under the discretion of the Supreme Court, it can be extendable to other cases also. Why? What is this? What is the necessity? The only thing is, as Rusky Pound says, according to the felt necessities of the time and changing the circumstances in the present day, law should change because change is wealth of time. When society changes, law should also change. And at the same time, even Wendell Holmes also said, law is not predetermined. If at all determined, that is only a guideline. So, according to the felt necessities, law should have a very good transformation. It should have a good change in order to meet the present day requirements. And this is about prospective overruling in brief. Thank you.